Hi, I'm Kim Rubenstein. I'm a professor of law at the University of Canberra, and I started teaching constitutional law in 1993.
And hi, I'm James Blackwell. I'm a Wiradjuri man and research fellow at the ANU and member of the Uluru Dialogue at UNSW.
This year is such an important year for the Australian Constitution because we're being asked to change it. Now, if you want to change something, you really have to know what it is that you're changing. So this podcast series is to introduce you to the Australian Constitution, all aspects of it, to help you when you make your decision about this referendum.
So join us for this 8-part series as we explore the Constitution, the law, the vibe of the thing, and Indigenous issues in this really important referendum year.
And indeed, it's not just the vibe, it's the Constitution.
In summing up, it's the Constitution, it's Mabo, it's justice, it's law, it's the vibe, and no, that's it, it's the vibe.
That was sensational.
So in this first episode, James, I think it's really important to talk about the history of the Constitution because in order to understand what is actually in it now, I think the context is really important. But the history, of course, of the Australian Constitution starts with colonial history. So I thought it would be helpful for listeners to sort of really think through the fact that there was a history before colonial history when we come to talking about Australia.
Yeah, and it's fun to note we've both got our copies of the Constitution out of our bags and holding them in our hands for this next little bit. So this idea of a Constitution, obviously, as you said, is very kind of 1890s, 1880s federalism period. We'll get into that a bit later.
Yep.
But yes, for 60 to 80,000 years before that period, we had 350 plus Indigenous nations around the country, around the continent, and the surrounding islands, all of which had their own essentially constitutions, their own set of laws, customs, ways of behaving, ways of being within their system and that governed their whole lives, much of the way the Constitution that we have in Australia governs much of the same. So, yeah, there's these pre-colonial or the Indigenous constitutions almost, existed around the country and still exist today. As a Wiradjuri person, our law, our boya still governs our way of life today. It still informs how we see ourselves, how we act in relation to the world. So, yeah, we have this pre-British history of independent nations, governing themselves and governing their relations with each other.
Yeah,
obviously, in the colonial period, we have the kind of the suppression of that, the often violent suppression of that history, the violent suppression of our languages, our customs, our law. All these things kind of get overridden by Britain, by the colonial powers from London, and for the first 100 years or so from the colonial powers from Sydney, and then from Melbourne and Adelaide and Brisbane and all the various colonial centres that pop up around in the different colonies. That's a very violent history. I mean, you could do a whole podcast itself on this stuff.
We could, and we'll come back to some of that, of course, when we have our whole session on the voice and the referendum itself. But I do think it's important to acknowledge that before I start going into the history of the Australian Constitution. But when we do talk about this colonial document, the Australian Constitution, it's based on the fact that the settlement of Australia by the British in that sense was not through a uniform central body called Australia, but in fact started off as the colonies. So
six independent little colonies.
That's right. So they evolved over time, and it came to the point in the 1800s that they were each regulating different parts of the country in different ways. And there was this recognition that things could be done better if there was some sort of central body. And I also always really like to point out the fact that the things that were really causing them problems at the time reflect on the way the structure flowed. So one of those things was the economic issues. There was a lot of contestation about the way we imported things from outside of the country. So were people supportive of free trade, and in terms of similar things that we hear about in discussions today about the openness of trade, or were people supporting more trade and business and custom in Australia by putting on bounties and customs and regulating that free trade. So there was a lot of discussion about that time about creating a better system for the economic advancement of the whole nation. But the other thing that was really causing a lot of discussion and concern was the immigration policy. And I think it's really important to acknowledge that at that period, the White Australia policy was the policy of the day. And in fact, there have been various conventions and meetings about the Immigration Restriction Act, and a bit of struggle with the UK because the UK acknowledged that it was happening but didn't want it openly. So that whole period of a dictation test and all those aspects of regulating non-white Australians was key for there being a desire to have a uniform Immigration Restriction Act. And in fact, that was one of the first bills that was passed, the Immigration Restriction Act of 1901. But I think that also links in very much to the treatment of anyone who was non-white also living in Australia.
Especially those who are already here.
Indeed.
It's a very weird dynamic to rock up to someone else's land and then try and restrict people who look like that from also then further entering.
Exactly.
Also, though, I should point out, you mentioned immigration and the economy. The one that I think people perhaps most jokingly remember about the reasons for federation is the rail gauges. So you're saying it's not the train tracks that was the main reason, because that's the one we all learn in primary school, and you go up to Moad and you learn it.
Exactly.
So it's not about the trains.
Well, those things were also other practical things that when we come back to talk about federalism shows that there was, that's right, a lack of uniformity around the country, that you'd have to get off one train and get onto a new train, exactly because they've been regulating things differently.
Of course, if anyone's caught the train to Brisbane recently, you still have to do that.
Yeah, that's right. So I don't think they actually overcame that problem, but it does reflect the fact that you have different laws in different states. And to this day, we still have some of those things that are remnants of that period. But yes, Indigenous Australians were not treated as part of the community in the sense of that recognition. But I should say, and this is another important point that we'll come back to on the session of citizenship, that anyone born in the territory of the British of the Crown was a British subject, and so Indigenous Australians were actually British subjects right from the start. But the key issue was that they weren't treated equally in terms of British subject status.
I think that for me, for a lot of people in my community, I think it contributes to that notion of the Flora and Fauna Act, this kind of debunked myth that we were classed under some act as flora and fauna, which is not the case. It's kind of 1967 referendum myth that's what that referendum achieved. But I think it stems in part from that system, right, where we are British subjects.
Yes.
But we are classed more in a sense of non-sentient creatures. We don't have the same rights to vote or the same kind of ability to act as people within the government, within the colonial system, but
yes.
Instead we're more kind of fenced off the way you might fence off kangaroos or emus, for example. And we all see how the emus get fenced off and massacred and things like that. So I think it kind of contributes to this kind of myth, or this notion that we were treated as animals, even if that's not legally the case.
Formally the case. And the other formal reality is that there were, as you've just pointed out, even though the status was there, the rights that we normally think of that go with status were not there. But I think what the other aspect to really amplify in this first session is who was involved in drafting the Constitution and what were their lives like that influenced. So I've talked a little bit about the policy that influenced it. But there was this desire to involve and have a sense of representative democracy in the drafting of the Constitution. So So at the beginning of the 1890s, there was a constitutional convention that was held in Sydney, but each of the delegates had been chosen by the 7 parliaments. But by the late 1890s, so there was the first constitutional convention then to discuss what would be in the Constitution. But then it wasn't until 6 years later, in 1897 and 1898, that there were further what was called the Australasian Federal Convention, which was held in New South Wales and Victoria and South Australia. And what was proclaimed at the time, and is true, is that it was as a result of elections as to who would be there to draft the Constitution. But again, when we say it was democratic, we have to recognise it was democratic at a time when the notion of who had the right to vote was vastly, vastly different.
I mean, it was diverse in a sense that there were guys with beards and without beards, Kim.
Yes.
Don't discount the guys with the long beards, the guys with the moustaches. There was some facial hair diversity there amongst the crowd.
Yeah, there were. I mean, there was, and I can pick up that facetiousness, and it's fair enough. And there were. I mean, for instance, I know that there were some Jewish Australians who were involved. So Isaac Frederick Isaacs was there.
Who had a great moustache.
Yes, so there was a limited diversity in terms of perhaps religious expression. But beyond that, first of all, we can identify that there were no women who were involved in the writing of the Constitution. But that said, there were women who were actually participating in the issues underpinning the Constitution. And I should also point out that we can actually identify the very first woman who ran to be a member of that convention. Her name was Catherine Helen Spence. Did you know about her, James?
Before meeting you, no. I do now know, though, thanks to you, that she was named as one of the top 10 men
Correct.
to run for the convention. So clearly a very capable and intelligent and articulate and passionate woman who
she was
perhaps
phenomenal.
should have been involved in the convention.
Indeed. And in fact, as you said, she was identified as one of the top 10 men you could vote for. But that was also around the time where they weren't actually sure whether she had the right to be there because she wasn't a man. And that came because of this tension with the fact that South Australia as a colony was the first colony to actually give women not only the right to vote, but also the actual right to be elected. So she was a product of South Australia. By the time of 1898, women were voting in Western Australia, so those women had a right to vote. But those women actually to this very day can be seen in this document that I'm holding up. Mine is green and James's is yellow, because Section 41 of the Constitution actually has a provision that would not have been there if not for the women of South Australia. And I'm going to read it to you because it gives you a sense of some of the issues that they were concerned with in terms of what sort of rights would be in the Constitution, because there are very limited rights actually in the Australian Constitution, and we'll come back to that later. But it says that no adult person who has or acquires a right to vote at elections for the more numerous houses of the Parliament of a state shall, while the right continues, be prevented by any law of the Commonwealth from voting at elections for either house of the Parliament of the Commonwealth. So in other words, if you had a right to vote in your state, you couldn't be prevented from voting in a Commonwealth election. Because those South Australian women said, we're not going to support a move to federation and to creating a Commonwealth if our right to vote is taken away from us, and moreover, if we can't vote.
Or restricted. It's one thing to be able to vote for your local council, but then to be told, oh no, federally it's not important.
Exactly. Now, the irony here, which links back to Indigenous issues, is that in 1902, the women who'd been campaigning for universal suffrage when the Electoral Act, which had been in existence since 1901, but by 1902 they'd amended it to enable universal suffrage. At the same time as they gave women the right to vote, they also excluded all Indigenous people from voting. So the move towards universal suffrage has that reminder of the discriminatory approach.
Universal-ish, perhaps.
Yes, that's right. Universal in a non-absolute sense. So that's an example of women being involved and the system at the time in relation to the drafting of the Constitution. But there were no Indigenous Australians who were involved in the drafting of the Constitution. And again, that reflects on discussions in the Constitution at the time as to questions about race.
Yeah, I mean, again, it's kind of unsurprising. I think for a lot of Indigenous people, perhaps, this idea that we weren't included is almost not taken for granted, but almost kind of like, oh yeah, of course we weren't. Like, it's just so fundamental, I think, to how we see that period for us that it's entirely unsurprising that we weren't involved. I think also for a lot of communities at the time, and perhaps even now, this idea that we wanted to even be involved in that process. Why would we want that when we have our own system of laws and governance? Why do we need to be involved in that? I think, and that kind of plays into an interesting debate we're having now. There's some who argue that, why should we have a voice? Why should we want to be in the voice? Or why should we want to have a voice to Parliament when we have our own system of laws and governance? And these questions that we're asking ourselves are still playing out.
Yes.
Today as to what level of involvement we want to have in that system. I think, for me, obviously, I think it's, we're stuck with this system. Whether you like our green and gold constitutions or not, it is what the continent's now governed by. Whether we can't go back to that system as much as we might like to, as much as it still exists. So, I think the questions around whether we should have a voice at all, well, obviously, we should. We weren't involved in the drafting of this document and have only been involved in one alteration to it since 1901.
Yes, indeed.
Which is in 1967, a good 56 years ago. Is that 50?
We're doing our maths here.
Yes, a good 56 years ago. So, we've had very limited involvement in this document, even not just in the beginning, but ever since. There's been up till now, we haven't really been asked what this document means to us.
Yes, indeed.
As Indigenous peoples, as First Nations peoples who've been here on the continent uninterrupted for 80,000 years, we've never really been asked what governance looks like for us. And so the Voice to Parliament proposal, the All Respect from the Heart that it comes from, is an attempt to rectify some of that absence by we talk about the dialogues in the kind of final session about the Voice to Parliament itself, but this idea that the government comes to us and goes, what do we want to see in this document? And this is the proposal that we've now come out with to kind of rectify some of this historical exclusion when we haven't been involved in the process.
And one of the things that I mentioned before about it being proclaimed in the 1890s as being democratic because people were able to vote for people to go, we've highlighted just now how that was a limited democracy. So anything that enhances democracy from a constitutional sense, I think, is an improvement to the Constitution. And the other theme that I thought I'd bring in here to finish off this sort of first introductory notion is that, of course, in setting up the Constitution, there were fundamental sort of themes, and they're the themes that we're going to continue with in our separate podcasts in this series. So one of them is the notion of representative democracy, and that the idea of that was there, but it was actually built into the Constitution with the sections that talk about electing people to the House of Representatives and to the Senate. So that's one notion. The other is that there is, in fact, a parliamentary system where there is a parliament, and we have two houses of parliament. We have the lower house, the House of Representatives, and we have the Senate. And that was also a reminder that there was a lot of American influence in the drafting of the Constitution, that some of the delegates had not only visited the US, but were in correspondence with some of the US parliamentarians or the senators and members of the House of Representatives over there. So they were bringing a lot from the US, and we see that also in the fact that there is a principle of separation of powers that we're going to be coming back to, that we have different chapters for the Parliament, for the executive and for the judiciary. So these are structural things that the people in the drafting of the Constitution were influenced by the US Constitution. But they were also influenced, because they were British subjects, of course, by the United Kingdom. And so we also see in this Constitution from the beginning a system of what's called responsible government, where we elect people to the Parliament, but some of those parliamentarians also are members of the executive branch, that is, the ministers.
And if you're Scott Morrison, you're every member of the executive branch.
So we have seen some very interesting discussions, constitutional issues that arose from that indeed, about the nature of responsible government. And Section 64 talks about a member of a minister must become a member of Parliament in order to continue to hold that role. They can have up to 3 months where after an election, where if it's not clear that they've actually been elected. And we had that historically, in fact, with Michael Lavarch, who was a minister under the Keating government, who became Minister of the Attorney General. I think it took a while before it was clear that he'd won his seat, but ultimately within the 3 months he had, and so he could maintain that role. So responsible government comes from the Westminster system, which is often the catchphrase for the English system of government. So in that drafting, we were influenced by the American Constitution. We were influenced by the UK system, which doesn't have a written constitution but has constitutional principles. So
it's just the vibe.
That's right. It is indeed a vibe that was played out more specifically with the fact that we do have a system that has a clear separation between the Parliament and the judiciary, but not a complete separation between the Parliament and ministers, and that's what we call responsible government. But the other key thing is, and this is very much what we said earlier about the negotiations to become a Commonwealth, was the negotiations over what would continue to be within the power of the states. The colonies became states in a federal system. And so one of the central sections is Section 51, which outlines the areas of lawmaking that the Commonwealth or the federal government can make, that the states can continue to make laws about as well, and there are provisions when we talk about our federal system.
Of course, when we get to that episode, there'll be a big discussion on the 1967 referendum, because I think a lot of people in this year, that's really become a focal point, is to actually I'm trying to understand what that referendum meant, what it did, and I think importantly what it didn't do.
Exactly.
I think there's a lot of misinformation or just lack of understanding as to what that referendum 56 years ago actually means for us now.
Yes, indeed. And so in having a sort of a structure laid out, it's really important to understand that constitutions really, as I said at the beginning, impact on our day-to-day lives, because it really determines who can and can't make laws and the extent of those laws. But the other thing we often think about when we're talking about constitution is rights protection. You know, that if you watch American TV, and a lot of people I think this is in the Australian Constitution by virtue of watching American television, is people talk about their constitutional rights. But the reality is that there are very limited constitutional rights in this written document itself.
I decline to answer that question on the grounds it may incriminate me. Which is not a right I have necessarily in Australia.
Well, you might get it through the common law, which is the courts developing those principles, but certainly not in the way the US talk about their amendment rights.
So I can't plead the Fifth for my speeding fines either?
Exactly. So, but what is interesting is, again, this is an influence of the British system, obviously more than the US system, is the idea that Parliament would be sovereign and that Parliament would be the body that protects rights. But I think in terms of our own historical evolution, we see, and Indigenous Australians are the perhaps best reflection of the fact that hasn't always worked in a way that protects the most vulnerable. So I've always encouraged people to recognise that our constitution may need a bit of updating on rights, and we'll come back to that. But certainly at the time of Federation, when they were drafting this constitution, they made a positive decision not to include specific rights protection in the way that the US Constitution does. They saw the creation of a parliament and representative democracy. But the one thing that they did see as being very important, and again we'll come back to this in more detail, is the power of the court to be the decision maker about rules under the Constitution. So Section 75(5) of the Constitution is one that I often refer to my constitutional students, but to know that there is a really profound rule of law built into the Constitution. The idea is that just because you're elected does not mean you can do anything. And some people think of majority rule as being sufficient to make something lawful.
Unless you aren't in the majority.
Well, that's right. And that's really one of the core principles of democracy, is that it's not just about majority rule, but also about those who are elected to act in a way that they protect the rights of those who are not part of the majority. And it's that balancing that sometimes is hard for parliamentarians to do, because they're responding to the will of getting back into parliament and a majority rule. And that's why courts are so important in our system of the rule of law. And for each and every one of us in society, we all need a court there to be able to protect us if there is an occasion where a government is acting in a way that is breaching our rights. And we haven't seen that. We've seen moments in Australian history where courts have been able to interpret things in our Constitution, like an implied right of political communication that we'll come back to later as well. But I think it's a good reminder that if we think back to the late 1800s, there was this belief that Parliament was the best institution. But if we look around the world to this very day, Australia is really in the minority in having a constitution that doesn't set out very clearly limits on executive power.
Unless you're a train track.
Yes, indeed. So that might be a point for us to sort of conclude our historical introduction, and hope that that's piqued the listeners' interest to come and have a look at some links that we might put for people to have a look at more information about the history. Or if not, they've
perhaps enjoyed my random joking interlude to your very serious conversation and want more of that perhaps.
Fantastic. Thanks so much. This podcast was proudly produced at the University of Canberra on Ngunnawal and Ngambri country. Special thanks to Rach White for her production. If you would like to find out more about the topics discussed in this episode, the Australian Constitution and the referendum on the voice to Parliament, please refer to the show notes for some useful links. The theme music for this podcast series is How to Vote by Patrick Hazler.